Thanks so much for introduction. Yesterday we have heard a lot of things from our novice and also from our police officer about the various data protection mechanism, the laws in place, information security and risk and compliance, and something on the what are the controls or mechanism are there in place to be in place. And we have learned a lot of things yesterday. So we are trying to continue the same journey today. So let's go through. Uh, 10 years ago, I was like this. 10 years down the line, today, I'm like this. Maybe 10 years down the line, I would look like this. Now, why I'm bringing this slide is to say that be open up yourself, be receptive for the changes that are happening around the globe. So be open to accept the changes, adopt the changes. Maybe your culture, maybe your socio-economic conditions. These are the changes we must have to adapt, go along with the changes that's happening in the industry and our social, this thing. All right, so let's get on to our next topic. So it's essential to understand. We have been talking every time that data processing, personal data processing. So let's understand a bit about this. What does it mean? Any operations we do on using the personal data, any operation for that matter, like what you mentioned there here, we might use the data, we might collect the personal data, we might sell it, restructure it, or use it, disclose it, or transmit. Anything you do, including the viewing of the personal information, it will be treated as a data processing. Okay, so maybe using the automated means or maybe the manual, doesn't matter over here. Anything to work on using the personal identifier information or the personal data is referred as a data processing. That's very much true. Right. So yesterday we have seen a lot of roles and responsibilities who are really involved in this total in the law framework, what they should do, what they cannot do. These are the things we'll discuss now. All right. So in the law framework, I have picked up which are most important here. So there is something called data subject or data principal. Who is that person? It's an individual or a personal living natural person whose data belongs to one person. Which means to say that an individual whose personal data is processed, that's called the data principal or the data subject. So while you are collecting the anybody's or individual information, it's obvious to say that you will have to get my consent or the entities must apply some sort of the legal basis for them to gather my personal information. This is the expectation or provision of the law. So while you are collecting my personal information, you must have to get my consent that you are collecting my data. What is the purpose of you collecting my data? How are you using it? Who are all giving access to that? Who are not having to process it? All this must be disclosed to an individual. So one more party called controller. What does it mean? The company who determines purpose and means of the personal data. The one who determines purpose. Why I'm collecting this somebody's personal information? What is the purpose of it? Am I collecting it for the issuing of a credit card? Am I collecting for the issuing of a bank home loan? Or am I collecting information for issuing something else? So the purpose, who determines the purpose and means that what? What is the medium or mechanism you are going to collect this personal information? Is it through some web portal? Is it through some conferences? Is it through seminars? Is it through door-to-door collection? So what is the meaning of? Means of the personal data. That is the one he's treated as a controller. So which means there are 2 points you like to understand clearly here, underline there. Purpose and means, there are key pointers over here. Alex, the data collect, they need to fulfill their defined purpose. So the who collect the data, the one who determines the purpose and means, he is allowed to collect only the data which are allowed as per his business purpose. not beyond that. So that is the one decided as, I mean, called as a controller, who defines purpose and means of collecting or gathering the personal information. Number three, there is one more party called processor. What does that mean? A company who processes the personal information on behalf of the controller, right? The company, I'm repeating again, the company which processes the personal information for the business purpose on behalf of the controller, which means the controller will transmit the data for further processing at the processor side. For example, if you take a look at the medical domain, we have a number of companies in US, I mean, hospitals in the US. Some of them would transfer those data for medical claim insurance or billing or coding, different purposes to the India. So which means in this context, the one who defines the purpose and means, he becomes the controller. The one who process the company which is stated here in India obviously becomes the processor. So that is where the position is. Processors are only allowed to perform operations instructed by controller. So this is the key over here. So processor should follow the instructions as per defined by the controller. He is not allowed to take any decision on his own unless, I mean, without the notification by the controller. He must abide by the controller rules and responsibilities and the terms and conditions laid out in their contract or business understanding. So these are the key, players and the parties involved in this kind of a law framework. Let's see data control obligations. Now we have seen those two parties are there. So one is the data subject or the data principal, and second one is the data controller, and third one is the data processor. Let's take a look at data control obligations. What they can do, what they should not do, what is their roles and responsibilities, obligations, and everything. Controller to comply with data subject and principal's rights. Like we saw in the previous slide, controller is the one who determines the process and means of the processing. So thereby he is in directly contact with the principals or the individuals. Which means in other way, he owns the data, he controls the data, he manages the data. So that way there are certain rights given to the individual. That is the primary responsibility of data control, to make sure that the rights of an individual is protected. That's point number one. Point number two, they must have to have written documented policies and procedures about what are the different personal items you're collecting, how are they processing, how are you using it, what is the purpose, who all have been sharing this, what are their different regions or geo location you have been processing it, who are all having access to that, all this, what is the security mechanism employing, what are the organizational security measures, technology measures, and administrative measures you have been employed. So these are all the different things, like we saw yesterday in the some part of the information security, data protection, like Navi was talking about it. So you must have to have the documented policies and procedure and instruction in place to make sure that whenever it's required, maybe during the law investigation or the any kind of a breach, so you must be in a position to demonstrate that. So okay, this is the standard operating procedure we have in place. These are the things. How do we do? So these are the vendor is going to do. These are the different ways of demonstrating the compliance. So he must have to have the different policies and procedures in place. Next, due diligence by the controller of the stability of the processor. This is the one more key here. When a data controller chooses to have a processor, he must make sure that the credibility of the processor should be good. Maybe in terms of finance, maybe in terms of handling the compliance or regulations, maybe in terms of handling the resources, or maybe data transfer. All these things you must make sure that the processor is capable enough to handle the the agreement and the contract laid down. So that is the most important one more key obligation of the controller. So next, they must be having the suitably defined confidentiality and data protection clauses in their agreement. So one more important obligation here that so the business environment will vary, the data processing environment would vary, the customer demands would vary. So because of all these variations and different challenges, technology related, customer expectation, lot of changes and demands are there. So your data protection mechanism may vary depending on the business environment. So accordingly, your agreement or a contract should be drafted in such a way that you must be in a position to take care of all the aspects of the risk that are involved in the personal data. That is where it is that confidentiality comes into picture, and also necessary data protection mechanism should be in place. Next, processor should have adequate information security in place. Like yesterday we saw from Naavi's speech, he was talking about information security. So it's all about CIA, confidentiality, integrity, and availability of personal data. So we must be having the in a place to make sure that necessary information security framework or implementation, like necessary governance mechanism, necessary policies, necessary tools should be in place to make sure that data, whatever the personal data being processed, is secured. And finally, we are protecting the data subjects or the principal rights, and also we comply with applicable law. Next, controller should support enforcement authorities. Like we saw in the yesterday, police officers were mentioning different law enforcement authorities would come into picture. Maybe police, maybe legal, maybe forensic analyst. Now, different laws enforcement will come into picture in case of any kind of a data breach or data theft or loss happens. So, data controller must have to support data enforcement authorities in case of any breach or investigation that might fall in. And place to handle data breaches and notification. Most important again, in case of any breach that happens, he must be having some sort of the mechanism to inform to the necessary data principal of the subjects, okay, and also to the necessary data protection authorities of the relevant country or the state, wherever whichever is applicable accordingly. Next, there are processes to deal with destruction. So what happens here? Okay, data controller is transmitting the personal data to the processor, but what happens once you're done with the process? Once you're done with the project, once you're done with the assignment, what happens to the data which I gave it to the processor? So in that way, there might be the clear understanding or kind of a contractual terms between data controller and the data processor about what do we do in case if you are going to terminate or in case we're going to end the contract with the data processor. So one mechanism either they have to return the data back to the controller or have to destroy it and they confirm that they have been destroyed, so and so. It all depends on what level of understanding, what level of agreement or data protection agreement it is in place. So make sure that it all has been put in, by the data controller with the processor. So these are the key, obligations of the data controller. Let us take a look at, data processor to how what is their do's and don'ts or obligations. Written contract or DPA. So, like I said in the before, he must have be having the written contract or data protection agreement in line with as expected by the data controller. So DPA stands for data protection agreement or a contract. So it depends on the business conditions and the business environment. What sort of contract you would like to go with that, or just with a DPA or MSA or contract. It depends on the business terms. But point is, I'm trying to tell you here. So there must be a clear understanding about what are the different data protection mechanisms you would like to see by the processor and also the enforced by the controller. And also you should be having the rights of the controller. So rights of is what? So okay, I'm transferring the data to you because of I'm the owning the data just because you're the processing the data. Of course, I do own some of the rights on those data. So what example if you ask me, I would say data controller may have be having the right to audit the processor. Maybe having, maybe you're part of your contracts. So right of the controller, that's what I'm going to tell you. Then avoid by documented processing instruction to the controller. Like I said in the before, there must be the documented instructions, policies, procedure in place to say that and this is the way, this is the how we are going to process the data. These are the different mechanism has been employed. These are the people involved. This is the location where we are processing the data. This is the terms and conditions. This is the employees. So all these things are should be clearly documented and put in place necessary with controls in place. Next, assure control by appropriate technical and organizational measures. So, like I was mentioning, here both are responsible and accountable. Data controller as well as data processor too. So, if you go by that logic, both of them must have to employ necessary organizational and the technical. Some of them are technical controls which will not to protect the data. Some of them are administrative controls, some of them are management controls. Depending on the the risk what you see, organization either it could be a processor or it could be a data controller must have to employ these kind of measures in place to make sure that we follow the law and also we protect individual interests. And the controller must and the processor must have to play within the scope of the law on as per the law. So there are some limits. You must have to play within those accepted laws framework only. Then engagement of sub-processor. For example, in some cases we have seen if the data processor is also not able to process the data, he may outsource to some XYZ for other further processing. Maybe for resource reason, maybe don't have capability, technology, and challenges, whatever the reason, he may have to go for some one more sub-processor. So in that case, he cannot take his own decision. He must have to get the approval or consent from the controller. Only when he say yes, then only he can choose. Without his consent or without his knowledge, he cannot go with any other suppressor for his business purpose. We'll continue this. Obligations. Next, cooperate with the relevant data protection authority in case of any investigation. Look here, I told in the previous slide that so in the case of an investigation, both are accountable, both are responsible, which means be it an investigation at controller or be it at the data processor. So we must have to make sure that be it a processor, he must have to cooperate with the data protection authority in case of any investigation or in lawsuit. Data breach report must be reported without undue delay. So, which means there is no periodicity within this limit or you'll have to notify your authority. There is no such thing. So, the moment you get to know that, we must have to make sure that the breaches has been reported to relevant data subject as well as the relevant data protection authority. It depends on the context. Next, if it is required, if the organization believes that the processor organization, we may be processing higher amount of data, personal data, we might need someone subject matter expert who can take care of, who understands the law as well as the technology perspective. So if it is required, it makes sense to appoint a data protection officer. And one more something called records of processing activities. In simple terms, also called as a ROPA. So we being a processor, we know very well that where the data is coming from, for all handling it, what data we process, how long we process, what is the output of this, where do we archive, where do we store it, these are all the recording of data processing activities. We must make sure that all this from end to end, the processing activity, whatever happens, we must make sure that these are all archived, these are all kept properly in the system. So that is what it is, a record of records of processing all the activities. Data control in case of any consequences of data breach, like we said in the about line item, investigation if it's required or any kind of a law enforcement agencies comes into picture, we must make sure that the processor also cooperate with a kind of a legal obligation. That is one more point. Then, so delete or return all the personal data. It depends on the context, depends on the agreement, what how would like to handle this in case of any project is terminated or project ended or assignment ended. So what is that you would like to do with the data which has been given by the data controller? So this is as per depending on their contractual obligations with the data controller, how would like to what is the best mechanism you would like to handle the personal data. Let's take a look at right to be informed. So far we have seen obligations of the data controller. I have picked up only the key obligations. Of course, there are a lot more you can read to in the net. So let's take a look at the individual rights. I being a individual or data principal or the data subject, what are my rights on my data I do have, I can exercise. Alright, so anyone has a right to be informed how the data is used. So I being the data who is providing my data to you, I have a right, it's my right to know that how you are using my data. This is my right. We must make sure that, or the company should make sure that he'll keep the individuals or the data subject informed about how are they using my data. Then the information communication, it should be concise, transparent, easily accessible. The information what you tell me about how are you using my data, it should be transparent. There should not be any kind of hidden agenda. If you are using my data for the processing of personal loan, yes, it's only for the personal loan. That should be clearly told to the individual or the data subject. Next, written in clear and plain language. So law doesn't tell you the language should be in English or the Spanish or any other. It depends on the processor and the where the data processing happens. Up to you to decide, up to organization to decide in what language they would like to publish this different information about to the individuals. So in cases we have seen some of the many companies, not some of them, they'll publish this kind of information in the local languages too. It could be German or the Spanish or any other French or the English as a standard. Different languages also they do publish, so that the data subject whoever is supplying the information, they're also well aware or well informed about how are those data being used in the environment. Right to access. Data subject has a right to access their personal data in case if you would like to understand what are the different data elements you have about me in a company, that is your right to know that from the individual. Either it could be from the processor or it could be the controller. So get a confirmation whether controller is processing or holding the data. So you can know, you know, you have the right to know that, okay, I want to see my data, whatever you have it in your company. That's individual right. If you want to obtain a copy, yes, you're allowed to obtain a copy. You can get it from the controller or the processor, depending on the context. So this is the second right what you have it as an individual. Right to rectification. It is something that if your personal data is inaccurate, if you believe so, or if they are processing incorrect data, you have the right to make sure that you can ask the data controller or the processor depending on the context, so you can ask it to rectify the necessary data. So we have seen in many cases that now somewhere pin code is not correct or name is not correct, spelling is not correct, So these are the things, allows the law is allowed to rectify the necessary corrections to be done by the data processor or the control accordingly. So you being we being the individuals or the data principals, we have the right to make sure that you process the right data. Right to erasure. The subject has to be forgotten or can require personal data to be deleted when. So if you think that you don't want to company to hold your data anymore for various reasons, you can ask the company to delete your personal data, depending on the context. Of course, if it's law allowed, you are asked to delete, I mean, asked to go for the request to the company for that deletion of the necessary data. Purpose it was collected if no longer exists. For example, in the previous case we have seen, let's say I have applied for a home loan or the credit card. So once the credit card has been issued, but you could ask to erase my data. But point is, for law agencies, it might be required for some certain period of time. So depending on the context, depending on the case-to-case basis, you might ask to erase the data. So in specific cases, for example, if you are no more using the credit card, which you obtained about it, let's say 5 years ago, and you've been using this credit card, you might ask him to delete your data. But if some case, let's say investigation is required or any kind of a lawsuit appears, so then he might to retain the data depending on the context. But this is your right to ask for erasing your personal data from in the system. Then the individual no longer consents. So which means I did give my consent, let's say about 3 years ago for processing my personal data, but I want to withdraw it now. So in case, then also you can ask the company to erase your data. These are some of the scenarios where you can exercise your rights. Right to restriction of processing. So in circumstances, the data subject may not entitled to require data control to erase the personal data, but you can ask him to limit the usage of data. You're not asking him to erase it completely, but you're asking him usage of the data restricted to only A, B, C, D purpose. You can ask those. So this is one of the 6 rights you are having as an individual or a data principal. Right to data portability. What does it mean? So I, being an individual, I have the right to ask my vendor, or I have a right to ask my data controller to port all my data to the new vendor. For example, you must have seen our cases in India. So we have been using, let's say in my example, I was using Airtel as my service provider. Now I would like to go port my number to the Vodafone. So which means to say that my data, whatever is already I have submitted to Vodafone, my could be my Aadhaar card or PAN card, whatever it is, they must be in a position to put all my data as it is to the new vendor, that is Vodafone, which means it's a data portability. So we being the individuals, we have the right to ask, please give me all my data or put all my data to the new vendor for various reasons. It is, depending on the context, so that I can reuse the same information and the same information which is there with the previous vendor or the data processor is no more with him. Okay, so that's the point over here. It allows them to move, copy, or transfer personal data easily from IT environment. Nowadays, you know very well that there is no business without IT. So each business has adopted the IT systems in one or the other way mechanism, so that the data whatever being used or the processed is safe and secure in all the aspect, and also thereby we protect the necessary rights of an individual. We also stay comply with the law. Right to object. So an individual right to have the right to object to the processing of their personal data, forcing control to interrupt such processing unless there is a compelling legitimate ground. So which means to say that if you want to ask and control of the processor, why are you processing data? That is your individual right. You can object him. So without my consent, without my notification, you are not supposed to process my data. Just because I have seen many cases that I have given my data for the processing of a credit card, but maybe after 2 3 days I'll get a call from the loan department. Why is it so? You can object him. You are allowed to object. So without my consent, you cannot process my data without my notification. So that's one more right of an individual called right to object. Next, right to restrict the automation decision making. We have seen nowadays lots and lot of businesses are adapting artificial intelligence or machine learning, ML, as a part of their IT applications enhancement and those things. So in some cases, we know that very well that many things are automated. System will make a decision. The human intervention may be very limited or may not be there even. So in case these things get to know that okay, this is a being processed by automated algorithms, or the computer system will make a decision on behalf of human. So you are ask them to restrict it. We have seen some cases, nowadays, our health insurance claim processing. It seems that it has been automated. The moment you submit all your hospital details and your discharge report, everything to the system itself automatically will calculate what will be the claim amount you are eligible for this. It seems that system will make a decision on behalf of the human. So that's where the point is. You are allowed to restrict the usage of the decision making system. So everyone has to have the right to express their opinion and the decision making and also the human intervention taking a decision. So these are the few things that where the computer algorithms is being employed in place of human being. Right. So anything for that matter, be it a data processor, be it a data controller, or be it an individual, everywhere accountability is the key matter. Unless we accountable for the things what we do, what we perform, so it's not going to help anyway. So everywhere, being any law, being any standard, first most things, the expectation is about the accountability. Is there a governance structure? Is there accountability structure? Is there roles and responsibility defined? Who does what? In case of when something goes wrong, who should be approached? Who should be approached? These are the things which is a part of accountability perspective. So everywhere key matter is the accountability. So with this, I'm ending my session. If you have any questions, I'm open to those.
Yeah, thank you, sir. Nagendra, sir. It was an
Thank
excellent
you.
discourse on the obligations and rights of principals, as well as you have also covered the individual rights. As an individual, what right I have on my data or data which pertains to my employment or my surroundings. So
Right.
there are many comments which I have received on the chat box. Everyone has maintained, everyone has said that it's a wonderful session. It is very informative, very good, very precise, and all those exclamations are there on the chat. There's one question by Ms. Arya Krishnan. So, what is the relationship between controller and processor? Can the controller be vicariously liable?
Very much true. Very much true. That's what I'm saying here. The obligations and accountability and responsibility lies between both the parties, be it a processor, be it a controller. The depending on the scope of the process, depending on the business, the liabilities lies on both. Of course, in some cases, it depending on the context. In some of the depending on the law what we are enforcing, depending on the law, it may vary. But ultimately, the accountability and the responsibilities lies on both controller as well as processor too.
Yeah, so that answers Ms. Arya's question. Uh, in continuation, I would like to throw some light on a few things. Many of the individual rights that you mentioned, sir, the right to access, right to erasure, right to portability, right to object for my data portability, and right to restrict the automatic decision making in the mechanism, in that all these terms and all these, they are legal jargon and very much vague in nature. So is there any effort in precisely defining the boundaries or the framework for this,
I
if there
think
is any
I'm not
effort?
sure. Yeah, I'm not sure as of now something is happening around because, like I said yesterday, Mr. Nai was mentioning privacy. The definition of the privacy itself is varies. You
Sure.
know, The privacy, the meaning to is different from privacy meaning to me or to somebody else. So if you go by that logic, defining the exact terms is quite challenging. But I'm not sure already something is placed. Of course, in the US or in the European, something might be working on. But currently, I'm not aware of this. Something is there.
Yeah,
But of
even
course, you will find kind of different literatures around this. Of course, and also it depends on the business context too. Interpretation of the law, interpretation of the business, which is necessary obviously to employ those controls. It depends on a lot of factors. Accordingly, you like to determine these things.
right. Even the Honorable Supreme Court also recused itself in defining these privacy. The definition of the privacy in itself
Yeah,
is the way.
exactly.
There's one
Yeah,
more question. Just now it has flashed. Mirza Muhyiddin Beg. When we download any application, it asks for a permission. Most of us, without reading full agreement, grant the permission. What are risk of data in this?
yeah. So I being an individual, I must be aware because in this case, whoever sends you that information, his responsibility is done. He had told you to read it, but not reading, the fault lies with us. Many cases we have seen that, even including the NDA, where you sign the employment contract or NDA, without even reading into that, we sign off. You know, we don't know what terms are there, but without understanding and reading it, we sign off the contract. So later realize, oh, this is what I'm not supposed to do. This is how we should do. Oh, something went wrong. So that liability lies with us. We being an individual are we also accountable to read and understand. Then you sign off that. That responsibility, accountability lies with individuals too, because you that is your right too. Individual right also it is.
Right,
For
right,
some reason you are not happy with that condition or the terms, you can go back and ask the company, so why is it so? You can ask them to modify, change, or whatever it is. So it's all our responsibility, and we're also accountable to read, understand what are the terms and conditions too.
right. So rights becomes right to us only when we understand the responsibility
Very
for
much true.
acquiring those rights. That's true,
When
sir. That's
when he gets into the court of law, you can't say that, no, I didn't read it. Was you signed it?
yeah.
That's where individual responsibility lies.
See, all in all, it was an excellent session, sir. For any organization that you define that the policy, procedure, the personal, everything has to be, the mechanism has to be
Yeah,
pronounced and it has to be in place.
right.
And every individual who is related to any organization or whose data is maintained in that organization is liable to, is entitled to have the various rights that his data would be used in a particular way.
Very much
So
true.
I thank you on behalf of everyone, and it was an excellent session. The same is the feedback given by all the participants also. So
Thank you very much for giving this opportunity. I also thank Dr. Shraddha Patel for this invite. Excellent opportunity. I see a lot of the participants with excellent questions coming around on this particular topic. I also like to thank Mr. Navi sir, for pushing me on to this and giving this platform. Uh, so, with all these introductions, we have also seen a lot of other topics on data protections already covered by some of the respected speakers, including Mr. Navi sir as well as Nagendra just before. So I will jump directly into those issues that typically comes when we talk from a data protection standpoint, because the data, when you talk privacy, privacy is more from a regulatory landscape, but it also has a kind of overlaps where certain regulatory landscapes that you need to comply would need to also fall an obligation that may arise from different sources. So let us see what is actually expected from a compliance. A compliance is when you either as an organization acting as a data controller or as a data processor, the expectation is to make sure that the basic principles of privacy are almost complied by the organization on the one side. Second, the rights that are expected that the data subjects or the principles, data principles that are expected to have are supposed to be given. However, we all knew that from the discussion the previous session when the Nagendra covered the data subject rights, these are not absolute rights. They have their own caveats around it. So, so typically, whenever there is an organization which is processing a personal data, it should comply with this legal and regulatory requirements. Basically, that processing is expected to be lawful. That's one of the most essential element. If it has to be lawful, then the processing can go forward to meet the other criteria that are expected from a legislation standpoint. The second, the collection should be fair. The fair in the sense there are two aspects to it. One we can presume from the sense of how fair it is in the choice that is given to a data subject or the principal at the time when the data is collected. So that choice clearly goes back and refers and sits around along with the rights that the data subject has as per the regulation. Second, the other aspect of fair is in terms of okay, I have a purpose. For example, I want to issue a SIM card from Airtel. For issuing a SIM card, Airtel, I don't need to collect an individual's hobby details, or I do not need to collect data belonging to what is the spouse information. What is your, do you have a, what is your salary? What is your anniversary date? Because these are informations which are not proportionate to the extent of purpose for which data is being going to be processed. So it needs to be also fair. And there needs to be a transparency that whatever the data is collected and processed by an organization, there should be a clear exhibit of notice communicated to the data subjects of not only from the purpose standpoint, but also from the rights that the data subject has according to the law which he can exercise in the court of law. It is not essential. Now, one of the questions that I happened to see was we do accept most of the privacy notices when we install an app. But still, even though, unlike the example of the non disclosure agreement, even if you accept a privacy notice, you still have a right which where you can go and exercise either to opt out or request for additional information. And this is some of the most important aspects that the privacy notice covers. So, as the previous speaker, Mr. Nagendra said, it is the responsibility and accountability of that particular individual, to take that kind of lead towards to understand what and what kind of information this particular entity is collecting. Now, the most important thing is protect. So, any personal data, in order to maintain the privacy nature, it needs to remain confidential. And binding to be the confidential, it also has to make sure that the particular information is processed for the purpose that are stated on the above three requirements. So these are the general expectations. So typically from a compliance standpoint, that organizations needs to be mindful and vicariously liable in case even one of the requirement fails. So, typically, what are the sources? I mean, typically the data privacy, when we talk from a data protection standpoint, we see there are different kinds of laws and regulations across the world. Certain things that may come directly from a central law, or it can be from a state law, or in certain exceptions, like for in India, you can also see for financial sector related, RBI has special codes. Similarly, in US, you have sectoral codes. Like a same attribute of data is not applicable for in a one particular law. So, if you are for example, if you are collecting a blood report from a hospital, the relationship between the patient and the doctor is bound by an obligation law called as HIPAA, the Health Information Insurance Portability and Accountability Act. Now, the same blood report is collected from a university student in an infirmary which is present within the university, then HIPAA is not the legislation that applies. So in that case, there is a separate sectoral legislation called as FERPA, which is the Family Educational Rights and Privacy Act, which applies. So, and if the same blood report is used for a genetic or a kind of a research purpose, there's another legislation called GINA that applies. So, there are certain countries on the world, specifically when we talk the US. Australia, New Zealand. These kinds of in this countries specifically have sectoral codes, and these sectoral codes and laws bind an organization to be compliant with along with any federal and state laws as well. Now, on the one side, we have compliance to be made from a legal perspective. There are other aspects within the legal perspective which decides that an organization should provide, implement reasonable security measures or provide measures in place to make sure the mechanism to address a complaint is effective. So when you go to that particular perspective, the only aspects is there are no industry standards, and most of the industry standards, even if it is, it has to be referred to some of the ISO standards that we have. So ISO 27001 talks about the information security management system under the concept where any personal data related processing can be given the same level of protection within the context of an information security. And recently, the last October, the ISO released a new standard in addition to ISO 27001, that is the ISO 27701, which specifically talks about personal information management system. So, in an organization, in order to adhere compliance and to meet requirements from a regulatory perspective, these are some of the requirements that are laid down in these standards, and these standards are usually adopted by the organization as part of an organization's regular process and policies. There are other standards such as ISO 29100, ISO 27018 specifically for cloud related, because as we see, there's a huge technological advancements in the event of cloud that we have been seeing in the market. The first initial standard was the BS 10012, and this particular standard was available right way back in the 2000 beginning, and this was adopted by the British system, and it is yet to be captured as part of an ISO, but it continues to retain and has the same effectiveness of ISO 27701. We also have standards, something like PCI DSS, which specifically regulates about the use of credit card informations. I also refer about the HIPAA in the past, which talks about an administrative rule from a security standpoint as well as from a privacy standpoint, which are deployed in order when a protected health information is handled. GLB talks about Graham Light's Bliley Act, which is primarily applicable for financial sectors in the US industry. And more than ISO standards, the US organizations falls back and applies NIST standards, the National Institute of Standards and Technology. Their standards more because they feel that is more effective for an organization which is having its base in US. So typically in organizations in India, you will see there is a mix and match certain standards from ISOs as well as from NIST, because ISOs are certifiable standards, NISTs are not certifiable standards. They are guidelines, standards that are issued, which helps organizations to meet and adhere to the requirements. Now, then there's other source where compliance is always spoken about. When a service provider is providing services to a particular client, the contractual obligations that the parties agree will also dictate certain compliance requirements that the organization needs to comply in order to be compliant to the legislative perspective. And certain things are from a GDPR, which is the EU General Data Protection Regulation, which came in 2018. This particular law has an effective way to see that it's just not the client or the actual client who is accountable. It also puts certain direct accountability on service providers. And as we know, a lot of outsourcing industry happens in India, and these Indian industries are also affected by this particular regulations, which emphasizes the organizations to implement the necessary compliance measures warranted by this particular laws. So the contractual obligations are also cascaded towards the organizations as a source that expects to meet compliance requirements. Now, try to cover what are the high level issues that you typically see when an organization is trying to adopt a compliance strategy in order to meet with the data protection requirements. So these are the five major things. One is the accountability, governance, and transparency. We'll talk about it much in detail in the next slides. The second requirement is the contracting requirements, such as basis of processing and other aspects, which most of the regulations you look at the EU GDPR, you look at the Indian Personal Data Protection Bill. There are several areas which are left unanswered, leaving it to an interpretation that can be by the authority which needs to be set up or by means of cases and precedents. So there are several such cases. Third, one of the most important thing, and this is a significant issue that we typically see, is people. People is also one of the biggest issue when compliance is expected to be, the compliance strategy fit the requirements of data protection laws. Process, and last but not the least, the actions. So when you talk about accountability and governance, the laws post GDPR era, which it can, because it was a remarkable process, because the laws that are getting repealed, any new laws that are coming in place, irrespective of, it's just not the EU alone. If you talk about the Thailand law, the Philippines, you talk about the Indian Personal Data Protection Bill, the recently effective law that came in Dubai and South Africa, everything has the flavor required from the base of the European legislation, which we call it in short as GDPR. And this has become more from kind of a framework for countries to come out with laws. So one of the significant aspects, as Nagendra said in the last slide, in the previous session, accountability is one of the most important things. There are certain areas where there are direct obligations on a entity, and there are also certain indirect obligations on an entity. There are extraterritorial reaches where, so if an Indian organization is processing a personal data on behalf of certain clients who are in a different regions, to what extent of territorial reach is always interpreted and is always a cause of accountability that results where that even the Indian organization needs to meet the requirements not only from a personal data protection bill perspective but also from the other countries' legislation compliance. So you will see organizations in India trying to meet requirements, trying to have a compliance strategy to meet requirements under HIPAA, under the GDPR, under the PCI DSS standards. So this extraterritorial reach is one of the significant issue, and in certain cases they are overdone to see to that in order to ensure that we are not penalized, in order to ensure that we are not overstepping or missing out on some of the most important things, the accountability perspectives have become a bigger issue to have a huge compliance framework with a lot of items that needs to be tracked by the respective stakeholders in order to showcase themselves the compliance standpoint. And in certain cases, when we talk from a transparency purpose of processing, sometimes what is at the time, an example could be at the time when an employee, the onboarding requirement significantly states, or even in the kind of a marketing related requirement, when a notice is issued, a notice is supposed to be for that one single limited purpose for which data was collected at that particular point. But what you typically see is the purpose of processing is totally arranged as an umbrella that even the future needs that the organizations may feel are also input as part of a transparency requirements, which leads to a huge compliance related in certain organizations, in certain countries, it may also end up with 2% of penalty of an annual turnover of a company. So transparency is one of the significant issues that we see where in most cases when we there are audits done, when our assessments done, we find the notices which are given to the data subjects at the time of collections are not in compliant with the accountability and transparency. Now, adoption of frame demonstrate compliance. So we are talking about an organization which is having its one, which has location in only one country, then it's significantly easy while you process. As long as you provide services only within that location, you don't have a challenge. But we see organizations, they have global presence. And when the global presence, being the presence, they have to comply with wherever they are located, that country law. Second becomes an issue is about to what services or what customers you are catering your services. So there are additional jurisdictions that form as a result of which an organization fails to implement an appropriate data protection program by not choosing a right framework and a framework that can really help to meet at the global level, at the same time also have an hybrid approach only to make certain deviations where it is applicable. So what happens is if you start trying to adopt a framework under the personal data protection bill, but you are spread across the different countries across the continents, and if you are stating that your compliance program meets that requirement, it's absolutely a flaw. And that system will definitely result in huge number of non-compliances. And last but not the least, from the accountability and governance standpoints, is the risk. The risk is something which is very clear that when a data protection comes into place, the risk that can impact an organization is not much crucial from a legal and regulatory standpoint because the law expects if the risk or impact that to the data subject is much more trivial that organization should take. Why? Because it is their interests and rights and freedoms that needs to be given a priority more than a business interest. So one of the best examples that we can see in the current we are witness due to COVIDs and work from home, lot of projects have been delivered from home. Now the clients have been insisting about why wanted to make sure that when the people are processing my work or they're working for me, I would like to visually see and record the entire activity from the time they sit until they shut down the system. Now, this are a huge impending risk. Now, this is a business interest, and there is another interest because even if an individual is at home and it is my rights because it is my personal space as well. I may have other aspects that are getting recorded and how this information will be used. So my rights, which may even end up leading to my termination of a job or no, or for any other embarrassment purpose can be utilized by the organization which is collecting this data. So you see a business interest on one side, on the other side you also witness a huge issue of privacy rights violation that may happen. So unfortunately, this is one of the major issues that the risk where business versus individual rights, that's where the whole context of non-compliance gets triggered. And most of the times we have seen authorities across giving more priority to the individual's interest more than business interest. So this is one of the system issue which we see from a compliance standpoint. Now, we also spoke about certain contradictory requirements. In in every country, there are certain. In US, it has a very different model. In Europe, you cannot, from an employer-employee standpoint, you cannot process personal data using consent as the basis. The reason being, according to the courts, according to the European Data Protection Authorities, we have significantly seen that the authorities come to the point that when the data subject is an employee and he gives certain information or information is collected from him, he is not giving on his own voluntary because there is a fear within himself or herself stating that if I don't give this information, I may end up losing my job. So it is always not considered voluntary, so consent is not used as a medium. But what happens in certain other jurisdictions, we wanted to talk about countries, I will speak with the Indian Personal Data Protection Bill, countries which are there on the Latin American countries, they they use only consent as the basis if you wanted to process a personal data. So, context of an organization, is it between a public and a state, or is it between an employer and an employee, or is it between a business consumer? There are different kinds of relationships. These relationships are not appropriately, and they are all addressed as one and the same, which leads to huge compliance issues if you try to adhere to certain issues, certain standards and framework. The technical and organizational measures. So typically, even if you go and visit our Indian Data Protection IT Act 2008, under which we had the IT Rules 2011, which is the current data protection law for India until the Personal Data Protection Bill comes into existence. The Rule 8 very clearly states that if an organization can comply and implement technical organizational measures in line with ISO 27001, it is sufficient enough to demonstrate that they are compliant with the regulations. Generally speaking, this is a float because from a privacy principle, security is just one part of an element. It's just security is just one element of the entire privacy concepts because you need transparency, you need openness, you need accuracy, you have enforcement. There are several principles to it, and security is just one part of the element. So, and an organization's ISO 27001, is basically a risk appetite that is accepted by that particular organization. This is not standard. Every organization which wants to implement ISO 27001 has its own standard and this own risk appetite based on which the controls are chosen and those are validated and against which the certification is issued. So relying heavily on ISO 27001, not the 27002, which is the best practices, but more from a 27001 is totally a flawed approach that leads to several compliance issues when we try to, demonstrate our compliance to a data protection laws. We already covered from the likelihood and disproportionate efforts. So, likelihood of risk and harm to data subjects is always overruled by the business interest of the organization that results in these definitions not very clear in any of the regulations, which leads Rome that the harmness, the meter needs to triggerly say that the high harm cost is very well decided and left for the businesses to determine. And that guidance has not been clear, also clear gives room for a lot of non-compliance issues to be opened up. Disproportionate effort responding to DSR. So there are different efforts. So DSR is one of the requirement that Mr. Nagendra had covered it in the previous slide, which is, talks about data subject rights. But most cases we see this are used by data subjects who are disgruntled, who wanted to exercise these in order to cause harm to the organizations. They're also used by people in terms of researchers. So a significant aspect that happened is when GDPR came into existence, there were research agencies which started issuing to all organizations certain DSR requests, which had no way relevant to any data being collected and processed by them. So, after a significant analysis, the authorities came to a conclusion saying that, irrespective, there was a diversion of view. The Kennel, which is the French authority, said that irrespective whether it is a valid request or an invalid request, it is the obligation of the organization to respond within the timeline and also provide the justification why the request is rejected, even if it is so. And reporting of breaches 72 hours. The 72 hours is one of the most trivial cases because it also depends when the actual time starts clicking, when you become aware of the organization. So typically, understand in a scenario where there's a client contract, client engagement, and you see there is a mail that comes from a particular, I understand that there is a potential breach or an incident within taken place because particular information was uploaded to the third party website. Now, what happens at the end of the day is the person who is handling that, due to his lack of awareness and lack of issue, the notification to the right stakeholders to take necessary action is totally, the clock has already started ticking. As a result of which, the organizations, most cases, do not meet the 72-hour deadline. And at the end of the day, they end up paying huge penalties later to the organizations for failure to adhere to certain compliance requirements. So, and because of these contradictory requirements, these not being clearly explained across, there are several aspects where the compliance flaws does happen. People, yes, humans still remain the weakest link in security. It's either due to their negligence or due to the lack of awareness. This is very significant and this is essential. And this has not changed in the past 20 years, 2 decades, because it continues to remain, as a result of which you still see a lot of increase in cyber threats. The most ransomware attacks or any other attacks that you would have witnessed in the global market are implemented or impacted by the simplest of the simplest thread, which is the phishing thread. Somebody sends an email with a link, and that link being clicked, the whole organization shuts down. So, phishing and social security, social engineering attack are one of the weakest link. Typically, in the information security world, we call that as the low investment but high returns attack. And it doesn't need much in the world currently with Facebook and other informations where informations about the individual and close connects are there across, spread across. This really increases the concerns, and it's the people's uh, to what extent the data an individual can put on the online, it is his responsibility. But at the end of the day, the data he puts about himself and the others also expects to be protected. At the same time, when there is a flaw, a disproportionate disclosure leads to huge compromises for the people at the wider public at large. Process one. So the setting of the compliance checklist as kind of an Excel checklist, what these regulations, the Personal Data Protection Bill and the GDPR or any other data protection regulations comes as, they are mandating for visual evidences and records. They expect compliance to be made sure that there are internal evidences that maintain inventory of managing records of processing. Any filing system that you typically in the past had to put it in file is now being expected to be maintained and managed as part of a significant documentation, which will be a crucial evidence for authorities when they inspect. You the requirements that an organization needs to maintain huge level of documentations to demonstrate that it is accountable and it is demonstrating its compliance towards the laws that is there. Irrespective if it is a PDPB or is it the GDPR, if you don't have these documentations, that means one of the key principle accountability you flaw, and that results in huge non-compliance, which may increase a person penalty. Software by design is one of the significant component. This a kind of a best practice, but now it has been brought in as a kind of a legal requirement. So, where any application or product or anything that you come into the market, before you introduce it into a market, before you introduce the architecture of it, at the kind of the strategy and design stage, it is expected that privacy should also be considered as part of the strategy group. So it is expected that the organizations should do appropriate impact assessments, data protection impact assessments, to ensure that in such a case where a personal data is going to be processed, the data subjects are not going to be harmed because the adequate controls and measures are already being evaluated and designed as a component of the product itself. Technical and organizational measures, which we already covered. There are different types of security as we see, and during this COVID, the scenarios keep changing. The remote work from home approach. There are significant changes, and as technology grows, as the cyber crime grows, there is a huge challenge to make sure there is a balance in this process of implementing the right measures in place. And this is one of the significant failure we have seen, when we talk from a privacy community where most of the privacy officers talk, they actually see this is one of the significant area where in most cases organizations ending up paying contractual liability to most of the clients. This is one of the significant issues that arises, and this needs to be assessed at the regular intervals, which are also processes failed. And because in every case the scope changes, the regulations changes, the necessary the processing changes, the environment or the perimeter within which the control certain processing had been done in the past changes totally. So each cases you need to evaluate and make sure that the right measures are put in place. So we feel that an umbrella arrangement takes care of these, but unfortunately, this is one of the significant failure that you potentially see when you in the data protection, leading to huge penalties for the organizations. Uh, there are also requirements from the authorities that each data subject rights or each incidents that get reported. When we say incidents, it's not the actual incidents alone. It's also the suspected and potential incidents as well as the actual incidents. They need to be tracked. They need to be evaluated. As an organization, use a process. You need to have a place to have the adequate RCA, which is the root cause analysis, to be carried out, and based on the root cause analysis, implement necessary corrective measures or preventive measures. So it's a huge process, and in any failure or any time lag in between this results in the flaw of a big, huge compliance issues for data protection. And wider and bigger the organization grows, this becomes much more and more complicated. The reason because there are certain or countries which provide certain data subject rights in a particular fashion. Then there could be certain countries this could be a derogation or this could be an exception for provision under that particular local law. So there are huge differences that typically you see from a process standpoint. And mechanisms to handle compliance is also one of the critical issue, which always goes for a failure because what should be the escalated mode? I mean, if the particular review is a complaint is being complaint from a data processing perspective is being rejected, is there an escalation mechanisms in place, and is these escalation mechanisms within the organization? uh, Hefty fines and sanctions. This is one of the significant the compliance costs versus fines and sanctions. So an organization's program to implement compliance strategy to make sure that they demonstrate the compliance across versus the fines and sanctions at an authority level. Even with you will see within the personal data protection bill up to 10 crores to 20 crores. It's a huge budget requirement. It's a huge requirement where sometimes your compliance cost, people feel that they agree to a risk appetite that if there is something that happens, we will see it when it matter and we will try to report. Unfortunately, there's always a question that comes from a business standpoint between what is the cost for putting compliance and what is the penalty that we will be living. So this is significantly there's always a failure, and certain areas, certain crucial areas are totally left unsaid and unattended by the organizations, leads to a huge downfall. So an organization's accountability should be more demonstrated by appointing the data protection officer. The role of a data protection officer should be very straightforward, directly reporting to the authority, emphasizes the team business interest must be vital for the role to be performed. So it's more in towards the data subject. The role in certain organizations where a data protection officer, they're also having immunity powers, and these immunity provides them to be very clear and exhibit to say what risk it may happen to the data subject, where the end of the day the company would be ending up paying huge compliance failures. So, and we also organizations has to put necessary requirements such as like the data protection impact assessments to be done at the regular intervals to make sure that there's a compliance failures can be taken care. And and as you see in the personal data protection bill, also the role of a data fiduciary, the significant data fiduciary and the guardian data fiduciaries, they have been highlighted, but we are hoping that the the authority once established provides clear guidances to the role that particular agency or that particular entity is going to fall within. So, in cases where organizations which are handling just employee data, but there are sensitive personal data and the concepts within which do they come under a data fiduciary or do they come under the significant data fiduciaries also has a significant challenges, and hopefully the personal data protection bill addresses these kinds of queries with effective guidelines in place so that these guidelines clearly put the threshold out clear to both the data subject as well as to the organizations, and appropriately the compliance related failures can be mitigated at the right of the compliance the strategy framework itself. With this, I like to sum up. Sorry for the first 5 minutes, but hope I was able to complete it in time.
Yes, sir. It was indeed an educative and a very exemplary session on compliance issues and data protection by you. As usual, I'll go through the questions. Few questions are there. This time, a little more questions are there. One, Mr. Santosh Patnaik has asked, compliance is something regulatory rules which individual company has its own. So, in which situation we can react like compliance is violating?
So, see, compliance also followed not only from a regulatory standpoint, but when you adopt a kind of a framework, you also have it as part of your internal policies and procedures. And as an organization aligns to a number of other standards and things, each and everything makes it a significant fact that the organization has to come. For example, the CMMI, the 9000, all these kinds of standards also are embedded within the policies and procedures of the organization. So, an internal assessment compliance checklist based on an hybrid approach of bringing both the regulatory as well as this, it will state the maturity of the organization. But let us not forget what is more important is more from a regulatory standpoint, because that ends up with huge penalties, whereas your failure of an internal system provides you the gap systematic where you can cure that particular gap by putting appropriate processes in place. So these are two different aspects, but however, you don't do a separate regulatory audit, you don't do a separate process audit. Sometimes they both are combined together in the lines of any certification standard that an organization proposes due to bandwidth or resource or other reasons.
Yeah, in short, the regulatory rules that a company makes, they are not at their whims and fancies, but they will have to be governed by some codes and regulating standards. And therefore, every individual will have the knowledge of what regulatory rules the company has made, and therefore the company is bound to comply with those things, and therefore individual is also protected by those regulatories. Right, sir?
Yes, yes. So it is it is left to the organization. So where the baseline needs to be. So if a regulation is the baseline, if there is a law that is taken as a baseline, you adopt it as part of your internal practices, and you assess your organization's maturity based on that is fine. But beyond that, if you want it to be a best practice, along with regulatory, you would also implement that. I will make sure that I have encryptions at 2048 bit across. I will not take and do these kinds of processing. So this is a very daring move which most of the times the organization doesn't propose. So they use a baseline and they stick only to the baseline, because you cannot overrule the regulations, because any overruling of regulations will end up with penalties.
Right, right. Beyond baseline is all right, but below baseline is not
Not
allowed.
accepted.
That's the
Not
thing. Yeah.
accepted. Not
Yes, sir.
accepted.
Yes, sir. Yes, sir. The next question is from a participant who is from Nigeria, Dr. Abu Bakar. What is the simplest step that the government agencies like the National Communication Commission do against internet terrorism or cyber security? In Nigeria, this is negligible. That's what he says. And what is the Indian scenario? He wants to know.
So see, when it comes to informations that are collected by, current law doesn't demand it, because we are falling back on IT rules which are applicable only to private entities. hopefully, under the data fiduciary being defined, where the state agencies also include unless or until they're exempted under the new bill, I think it needs to be applied. So, but if you take the same examples of organizations which are in EU, which falls under the GDPR, the European institutions, which are the government agencies, are supposed to adhere and strictly follow the requirements as similar to a private entities. For example, if the European authority in France, which is the Kennel, is planning to implement a DLP monitoring system for those people who are working within the vicinity of the office, it is expected that the authority was supposed to first conduct a privacy impact assessment. Based on the impact assessment, communicate the same to the data subjects, that is, to their employees, and it is only post that can implement it. There are also certain places in certain countries in Europe you have trade union restrictions as well, and you need to be a significant contributor to be part of the trade union, get the right approvals, and only post which you can adopt it. So it differs from country to country. I think specifically from Indian standpoint, probably I would like Mr. Navi sir to provide his thoughts. To my understanding, data subjects notices compliance to IT rules 2011 is not still applicable for India to any government agencies. So
Yeah.
yeah,
Say, in
that,
India, of course, we have to also look at the TRA guidelines, and that is in respect of the telecom industry, which the person was referring to. And CERTIN has got its own security guidelines. Basically, the security guidelines of CERTIN or TRA or whatever is that, originally focused only on preventing unauthorized access to the system. Okay, that was the basic
yes.
aspect of security. Now the privacy has added certain rights for the users. That is the only difference. But though Information Technology Act focused on, say, private sector or something like that, but TRA guidelines were already there, and which covers privacy also in a very big way. And CERTIN has given its own set of guidelines for preventing unauthorized access, for which you have to maintain the necessary ISO 27001 kind of standards that is applicable to the telecom regulation. So even in Nigeria, perhaps the department can have its own internal regulations for its licensed members, and even have the rights to conduct audits on their licensed members, withdraw the license if they are not following the audit, I mean, whatever security norms are prescribed, etc. So even without a comprehensive law, within a sector, it is possible to implement security measures. In India, when we talk of organizations, I would like to just make it clear that we are not only looking at companies, we are looking at even other organizations, including educational institutions like KLE kind of thing. That is one aspect. And for internal compliance, Indian law also says that every year you must have a mandatory data audit conducted by an external data auditor, like what we do in the case of financial systems here. So, even though the regulatory audit may or may not take place for years, for example, they may not have the time to check each and every data fiduciary. If there is a significant data fiduciary, there is an obligation for mandatory data audit, so that the organization has to do it itself within its organization. And Indian law also says that any such audit will have to end up with a number called data trust score, which has to be disclosed. So tomorrow, the regulatory authority will first get information about an organization. What is your DETS score? Then if it wants, it can conduct its own audit. So this Indian law has taken certain steps to implement certain measures at the organizational level, and perhaps it will separately look at how to regulate that. The other point I want to make is the codes and practices. Some information was asked. See, we are today in a stage where the bill is getting passed into an act. Then the authority called Data Protection Authority will be set up. And the Data Protection Authority will perhaps come up with, say, at least minimum of 20 to 25 guidelines on day one. And some of that guidelines will include codes and practices for different types of organization, maybe codes of data privacy for educational institutions, codes of practice for IT companies, codes of practice for health industry, like that. So that is the next level where the Data Protection Authority will come up with the regulations. Then perhaps we will have a complete picture. We have a basic understanding in the GDPR scenario because it has already been in existence for some time. There have been many sets of clarifications and codes which have come up because there was this WP 2940 and even EUDP is giving frequently some kind of guidelines documents. So there is already a body of knowledge available in the GDPR. Other countries like Singapore and others also have given certain clarifications in the past. We will, of course, keep that in the back of our mind as this is what is expected, and the Indian DPA will come up with its own codes and practices. Yeah.
Yes, sir. It was
Thank you.
nice
Thank you.
clarification. There's one more question by Advocate Gaurav Tanna. He has quoted his own case he has with a particular bank, whether failure by bank to inform customer to adopt additional authentication when transaction is done from another equipment or another device. Can I charge the bank with the IT Act section 43? He wants to know.
Can I
See,
add, Rajesh?
sir, this is your case. I mean, you bought it against, you won
Okay.
it against ICSA. So
Yeah, yeah.
it would be Navi, Mr. Navi sir would be the right person to say it. Please go ahead, sir.
Okay, okay. So this case which Rajesh was mentioning was by an individual customer against ICICI Bank, saying that because the bank did not implement adequate security practices as dictated by Reserve Bank of India's say 2001 guidelines and subsequently digital signature, etc., banks should be held vicariously liable for the phishing. This was actually a phishing, and the customer had even admitted that he had answered a phishing mail. So this was argued on the basis of, okay, the customer has committed some negligence, no doubt. He was unaware, he was a fool, he answered the phishing mail, etc. But what was the security which was required at the bank's stage? If they were also negligent, and if two negligences have contributed to the fraud, who was last responsible for the cause of this loss was discussed, and the adjudicator held the bank responsible. Then bank went to the appellate tribunal. In the appellate tribunal, this particular section 43 subsection G was taken, and there the TD SAT made actually an observation that non-observance of security guidelines could be considered as a passive assistance to commit the contravention. 43G says anybody who assists in contravention will be liable. So non-compliance of security laws, the court, TD SAT has got a quasi-judicial power, and it said that it can be construed as the violation or contravention of the act. Now you are talking of adaptive authentication. Of course, adaptive authentication is an advanced method of securing, and in the court perhaps you will have to say that most of the other organizations are having adaptive authentication. In fact, RBI has actually given a notification to the banks to use adaptive authentication, and you have to use that and try to convince the court that this is also part of the general information security guidelines. The bank ought to have put it in place. If they have failed, definitely it will be considered as one of the negligent features. And now, of course, RBI has introduced the limited liability system. So most of the cases you will get the amount recovered out of that. And one of the Kerala High Court cases also stated that, okay, the limited liability case requires an SMS to be sent. In that case, State Bank of India said, I have sent the SMS. This client did not respond back and say that this was a fraudulent transaction. Court said that you cannot hold the client responsible even if he has failed to respond to the SMS. So some courts are very, very consumer oriented. So any negligence of security practice will definitely be a ground on which you can try to say that bank should be held vicariously liable, which will be 43 read along with the sections like 85, and try to recover the money from the bank. There have been many such cases. Of course, ICICI Bank has been going from one court to another court, higher courts. So until it reaches Supreme Court, we still have to wait for a final word. But definitely, you have a point there. Okay, thank you.
Sure. Yeah,
Yeah,
just one to add to what Mr. Navi said. When we
please.
talk from technical security measures, it is not everything is technical measures alone. There are certain administrative measures also, which is part of technical, like you train the person regularly, making sure your employees are aware of the do's and don'ts, or your consumers' do's and don'ts, and then making sure the vendors whom you are engaging, appropriate due diligence done, background checks done, signing of an NDA, making sure. So these are also part of technical and organizational measures. So not to be confused that when we say technical, it's just limited to encryption,
Yes.
pseudonymization.
Sir, I think Advocate Gaurav has got his answers along with the case law. We have time for one or two questions only. We are already up to the time we have come. Uh, I could re-quote what you said. Human is still a weakest link. With the lack of with the negligence and lack of awareness, human is still a negligent link, and that is to be strengthened in order to have the compliance at all levels. One more question is, it's not question, in fact, it is Ramashankar Singh from Lucknow. He said it's an insightful session, and his personal view is that to amend many acts for effective implementation. His personal view has suggested that the amendments are required to many acts for its proper implementation. And then one more question is from Mr. Shravan, which has already been answered in the previous session about signing the agreement. I agree at the end of the. Uh, I think is it. Yeah, signing the agreement. The companies make it too long in order that the consumers do not read them properly, and they want to get them bound by
which
this
is
agreement.
which is totally
So
non-compliance because the laws are very clear that it is expected that when a notice is issued, it should be clear, conspicuous, and it should not have any ambiguity. There are requirements
intelligible.
where you cannot bind it with certain contracts saying that unless or until you provide this, I will not be able to provide the services. So there are several clear conditions. We are hoping the PDPP bill, once it comes, we may see a lot of challenges and pushbacks that may come, where organizations can end up with too much of compliance related failures.